26 USC 6903, one of the administrative codes that governs that Form 56. Notice a fiduciary relationship. Is there a tax liability involved in these account numbers guised with a semblance of legality called court cases? Sure, they are. Does Form 56 shift that liability from your end as a form of safe harbor? It does not. Let's go to the horse's mouth. In a position of confidence, this confidence is just another word for trust. And the word trust, when it comes to anything dealing with pen and paper, is not just a layman term of, oh, I trust you, go use my vehicle. You know, like a woman would trust a guy who basically serviced her engine real well down there, and then she trusts him all of a sudden by giving another engine to him. Or like a hobo would trust that guy down the street who's always giving them $5, $10, $20, and some days $50. That's a lot of money to them. Every time they wave to him and smile, they trust, okay, maybe if I act nice, he's going to give me more. Right. Like your cat or your dog trusts you to feed him every time he gives you cues. Confidence, trust. But in this case on pen and paper, the trust is relating to structure, functional structure of estate planning, or lack of full disclosure based on conscionability of a contract. When you fill out Form 56, you voluntarily place yourself in that position of a guillotine, face down, ass up, with a sharp metal coming down in your neck. And out of shame, they don't want to come out and say, this stuff does not work. Don't do it. Backwards. They were at point 0. They think they've walked all the way to 10, but in truth, they're a negative 10. For those of you who've yet to get to that point, or if you already have done the Form 56, whether you've realized it's a detriment or not, I'll show you how it's a detriment and the solution. Not from my own prerogative, but directly from the guideline of that same thing many people are filling out. Hello, 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 beautiful people. Form 56. Notice concerning fiduciary relationship. Most of these things relating to these forms, what the flaws are, how it further traps people, and what the solutions are affirmatively or potentially, are only brought up when I see that it's consistent, where people speak of it directly by bringing it to me or showing me certain things. When consistency begins to occur, and majority of the people who do that thing relating to the consistency sees the detriment in it, or later realizes it does not benefit them the way they think it is, that's when these videos come to life. I don't see the necessity of creating videos like these because usually it is discouraging to most people who have dedicated time to something, just to realize it's really not worth what they think it is, or that they've been basically bamboozled. Let me show you what this Form 56 really does. You've heard and seen probably more than a handful of people all over the internet speaking about this form, telling you to do it in court cases, and that everything will be all right, and the other parties will become liable because it's a tax matter. You will shift tax liabilities to people. Form 56 is not how the shifting or avoiding of tax liability works. In fact, Form 56, just like many of the things people are conditioned to assume works a certain way, like a sector for value or the whole private non-commercial plate, all that actually does the complete opposite of the desired outcome that people intend to get. Most of us here on this earth are stuck on the fact that what we observe with the 5 senses and the impulse of social interaction. Humans are social beings. We have mirror neurons. Match those two things with the intent to get an outcome and the desire for the reward involved. You very much have disaster. Most are convinced that the limits of reality is based on what they see, which leads them to what they think, rather than functioning backwards from what you think to what you see. This causes humans to become no different than other flesh and blood creatures, with rights and their enforcement, or the security of a person's papers in effect, one way or another. You must always see beyond what is physically observed, or what someone merely just tells you, matched with the social elements of many people speaking about it, aka the bandwagon and the hype train, matched with the thirst and the hunger for the desired outcome. And in some cases, some people want to add fear and anger. which makes it worse because you're blindsided. Let me now reveal the truth about what Form 56 really does. If I was to count it, it'll be about 32 different people that I've come in contact with that did Form 56 and expected an outcome but got the complete opposite, or eventually realized what they did was basically hung themselves. Let's go to the instruction of the Form 56. Those telling you to do Form 56, telling you it's going to shift tax liability to the acting judge or the courthouse because the court case is a tax liability, they're mixing and matching facts with falsehood. Is there a tax liability involved in these account numbers guised with a semblance of legality called court cases? Sure, they are. Does Form 56 shift that liability from your end as a form of safe harbor? It does not. Let's go to the horse's mouth. Notice concerning fiduciary relationship. First thing you need to know is this Form 56 benefits the one that you're assigning, and it's a detriment to you because you are basically alleviating tax liabilities from them by telling them to be the beneficiary further, voluntarily, expressly. So now there's no dispute as to whether there's coercion, whether there's stress, or whether there's lack of consent, either through incompetence or lack of full disclosure based on conscionability of a contract. When you fill out Form 56, you voluntarily place yourself in that position of a guillotine, face down, ass up, with a sharp metal coming down in your neck. Something tells me most people fill this out or hear people that tell them to fill it out or read some PDF that tells them fill this out along with some other form. Rarely do they read the instruction. And if they read the instruction, it is with bias of the social conditioning. Lack of independent thought will lead you astray. If you are in your teenage years, okay, maybe your brain is still learning what it means to be independent. But if you're past your 20s and your 30s, come on, do a little bit better than that. Because remember, you are part of society. Society is not some extension or some foreign thing to you. You make up that society. To which end of the extreme of the role you play determine the quality of that society and the quality of your contribution to it. The more you casually use social elements of just going with the okie doke without using your own independent thought, the longer you become a detriment to yourself and society at large. One of the ways you reduce that detriment and liability to yourself and others is to read. Read, read, and then read. Once you've read, stop to think. Do some self-reflection on what you've read and ask yourself, how does this functionally, not speculatively, how does it functionally applies to me? Only then would you realize that 90% of what most people go through, cracking the code, SBC process, all these social media hype train, is actually counterintelligence to your desired outcome, the opposite of it. And new people come in based on the social element of things and just jump along into it without necessarily using independent thought process. They expect to get the gratification within 46 months, 2 weeks, by just filling out a bunch of forms that does the complete opposite. They wait about a few years just to realize nothing is happening. A few more years, they realize they've screwed themselves over. Now they've actually walked backwards. They were at point 0. They think they've walked all the way to 10, but in truth, they're in negative 10. For those of you who've yet to get to that point, or if you already have done the Form 56, whether you've realized it's a detriment or not, I'll show you how it's a detriment and the solution. Not from my own prerogative, but directly from the guideline of that same thing many people are filling out, which blatantly, in black and white, conspicuously tell them, this is what it applies to, this is who it applies to, this is when you use it, and this is its utility. And as I always say, no different than the UCC forms, the numbers that come in front of the UCCs is based on the article of the Uniform Commercial Code that governs that form, like the UCC 1 financial statement, well, Article 1, even though they're all intertwined when it comes to instruments 3 or 9. With IRS forms, there's always a code within the 26 USC or CFR. In some cases, the Trade and Commerce clauses within the United States Code, not the Constitution and Trade and Commerce Clause, but the United States Code. In some case, you might look into some things relating to consumer laws that might intertwine the IRS in some cases. But this Form 56 particularly is governed by 26 USC 6903. Notice of fiduciary relationship. But we'll come back to that. Let's go back to the instruction. These rudimentary breakdowns are what you must know, or what someone is liable to transfer to you as the foundation before they start telling you to fill something out. If you don't know it, you just step into a battlefield, no weapons, butt naked. But the other party, they're filled with resources through their men and what their men use in battle, including the knowledge of those tools of battle. Purpose of form. No different than a declaration of trust, whereby the first few sections of that declaration of trust will tell you what the purpose is, one way or the other. These IRS form instructions are deliberately designed that way as a no-brainer, so it's easier as a form of template for people to comprehend, because all these forms of IRS deals with tax, and tax matters. Tax matters are intertwined with trust relationship, mostly constructive, but requires your consent of subrogation for you to go face down, ass up through your own expressed consent. Purpose of form. And then it defines, no difference than your trust. You would define who the trustees are by designating who they are. You would define through designation who the grantor, beneficiary, so on and so are. They give it to you here. And then specific instructions, which is, well, what are their responsibility? What laws applies to this trust? What is the extent of its applicability? Revocable or not? Are there subsequent minutes? Are there subsequent laws relating to it that clarifies and extends the power of the parties and the essence of this trust or not? They do the same thing in their instructions. Most people using Form 56 know that trust exists in such manner, at least I trust or hope they do. Yet, they fail to look at these forms and see the simplicity of it. Heck, they fail to even read it at all. Purpose of form. You must notify the IRS of the creation or termination, which is the solution, which right at the beginning is telling you if you screwed up using Form 56, the same form is the solution because you can terminate the relationship. You must notify the IRS of the creation or termination of fiduciary relationship. So the purpose of Form 56 is to establish or diminish or terminate. So the purpose of Form 56 is to establish or annul the fiduciary relationship. Fiduciary relates to anyone dealing with monies on behalf of another. Fiduciary is a trust term. Fiduciary is another word for trustee. What I'm about to show you here, according to this form, Form 56 also designates whoever you turn into a fiduciary as something called a designee or an assignee, aka a beneficiary. Did you know that? Did whoever told you to fill out Form 56 told you that? And there are many more forms on the back end that those establishments, aka financial institutions, fill out that you don't know about, that segregates you and actually bars you completely from being able to use that as legis in the manner that you want to, which is the danger that is essential for people to know about so that they don't screw around recklessly filling out Form 56. You must notify the IRS of the creation or termination of the fiduciary relationship under Section 6903, which we've just shown you a little while ago. So this is no speculation. There's a trail to what governs them administratively. And give notice of qualification. Like I've mentioned in many other videos when it comes to tax, it's all about qualification. If you qualify for taxation and then you're trying to say you don't qualify for it retroactively, that's called tax evasion. That's illegal. And you most likely would rip the negative portion, the shitty end of the stick. If you don't qualify for it in the first instance, then you've effectively avoided it, which is legal, which we went over in this video. It's on Patreon. You must notify the IRS of creation or termination. And the way that is done is through either a constructive trust, where you provide consent through Form 56 forms by joining theirs to subrogate yourself, or create an express trust, which has true function and dynamics privately, a safe harbor, which avoids those liabilities legally and backed by law. Two particular types of law: trust law and contract law, which is also covered by the constitutional law, which is the United States Constitution or your state constitution. You may use Form 56 to provide this notice to the IRS if you want to create or terminate the relationship. It's a form that designates and assigns a third party as a proxy on your behalf for financial liabilities. Why don't you just create an express trust and designate your own foreign trustee as that? Why are you doing this? Don't worry. You see the answer to that question pretty soon. Who should file? The fiduciary is the one that files it. Uses Form 56 to notify IRS, meaning the one that is designated notifies the IRS. In other words, you are not even supposed to be filling it out. They are supposed to be doing that, because there's supposed to be a predominant agreement that establishes that relationship. And IRS is merely being notified. Notice of qualification is not meant to be done by you. That's one. Two, Form 56 is done to notify, to provide a notice. Don't all these people who do this SPC stuff know about notice to agent, notice to principal? The second is Form 56 is meant to be used as a notice to IRS that someone else is acting as your financial proxy based on your tax liability, not lack of tax liability. And that's what attracts most people. They say, oh, wait, notice to the IRS that someone else has a tax liability. No, you still have the tax liability. Someone else is just speaking on behalf of you that you have tax liability. That's one of the things Form 56 does. To add salt to injury, it actually also allows them to designate themselves as a beneficiary to reap tax benefit. No different than the parents will claim their child in their tax return to reap tax benefit as a credit to get checks back. They're doing that to you the moment you fill out Form 56, even though you're not supposed to. They are supposed to, but you're doing it for them. You see where the counterintelligence is? You are voluntarily doing the opposite of your desired outcome, because now there's no excuse that you lack consent or knowledge because you voluntarily did it. Who should file? The fiduciary. Uses Form 56 to notify the IRS of the creation or termination of a fiduciary relationship under Section 6903. For example, if you are acting as a fiduciary for an individual, which includes a corporation, a decedent estate, or a trust, you may file Form 56. They are speaking to the fiduciary, but most people who fill this out and put other people's name, they're not the fiduciary. That alone is synonymous with tax fraud, because you are now putting someone else's name, absent of their consent, to take actions relating to your tax liabilities under the intent that you're trying to make them liable for your tax. According to the function of Form 56. Do you now see the other avenue that, and there are many USC codes that they can attach on people who do Form 56 just for that alone? Do you now see so many different paths that comes about as a detriment to those who fill out Form 56? And we haven't even gotten to the worst part, which is the slap in the face that shows that, look, this is the opposite of what you intend. Let's continue. And here it is. Receivers and assignees, they, the fiduciary, file Form 56, but they're not even the one doing it. You are the one voluntarily doing it, telling them, you know what? I want them to be the receiver. I want them to be the assignee for the benefit of creditor. When you do that, they don't give any credit to you. They take it. And you know what's left? The tax liability, which ends up as the complete opposite of your desired outcome. Receivers and assignees for the benefit of creditors also file Form 56. They are not doing anything for your benefit. They become the beneficiary. To give notice of qualification under Section 6036. However, the however portion is based on bankruptcy, which is another dynamic and use. Now, here's the part that many people find attractive that cause them to fill this form out. It says a fiduciary is treated by the IRS as if he or she is actually the taxpayer upon appointment. In other words, you're appointing them to act as you, but they're really not you. In other words, they're speaking on your behalf to sign, to consent to document on your behalf. They're not taking your tax liability. When you want to use a proxy, there's a way you use it properly that would actually benefit you. When you use it through this constructive trust and you express your consent to it through this Form 56, the constructive trust, by the way, being the courthouse that most people use this Form 56 in, you flip the opposite of the benefit upon yourself. This upon appointment is letting you know you're merely assigning a position. They're really not you. They're acting as though they're you. And the reason why the IRS treats them as though they're actually the taxpayer, aka assumptivus legis, is so someone else can speak on the taxpayer's behalf. Under the assumption of incompetence, minority one way or the other, either through age or incapacity of other means, plethora based on contract law. But now you're not even claiming that because you're providing voluntary consent by putting their name in it. Of course, we mentioned the issue behind that. And upon your appointment, the fiduciary automatically has both. Listen to this. Upon your appointment, by using Form 56, the fiduciary, the one who you think is taking the tax liability, automatically has both the right and the responsibility to undertake all actions the taxpayer is required to perform, meaning to file your tax return. It does not say they hold your tax liability, but the right and responsibility is for you to do voluntary confession by filing tax forms. So now you're getting lazy thinking they're going to do it for you. They'll fill it out all right, but they will become the receiver and the assignees that benefits. They'll become the creditor. They'll subrogate you because you're giving them the right and the responsibility. And what's left will be the tax liability in whose name? That name that you're trying to run away from. That's what people don't get. You want to be free, you have to do it yourself. Granted, outsource things, but make sure the one you're outsourcing it to is based on an organization that was designed initially, predominantly to benefit you by operation of trust and contract law, not based on speculation, not based on social element of bandwagoning, not based on your thirst of instant gratification. If you use those three things, and in some cases people will even use fear and anger, it would always lead to the opposite of your desired outcome. It then goes on to say, for example, the fiduciary must file returns and pay. And then it goes, for example, listen to this part, which most people miss, but go to the part that feels pleasurable to them. The fiduciary must file and pay any taxes due on behalf of the taxpayer. On behalf meaning it's still done in your name. It does not subrogate or transfer tax liability to them. That's the whole purpose of being a trustee, aka a fiduciary. But when it comes to money, is the same thing as a fiduciary. It does not involve them personally. It is still being done in your name as though it's you. But now they only have the responsibility of the toil involved. But when they do this filing of returns, they're not so stupid because the same form allows them to benefit by being assignees and receivers of those tax credits. You're not getting any. How many people have done Form 56 and told you they got some tax credit back from the IRS? You wouldn't hear it. It's just a bunch of speculation. Because at the end of the day, it did the opposite for them. They don't want to come out. Now, only very few people come out and say, oh, look, this stuff doesn't work. And the ones that do, when you go into the social media pages, they get bombarded by other people who have invested so much time and money in it, they don't want to accept it's true. An authorized representative is treated by the IRS as the agent of the taxpayer. Agent of anyone's agent don't hold personal liability for the one who they're acting on behalf of. No different than if you go to a clerk. That clerk you're filing papers with is not the actual clerk of court because they didn't get sworn in, but they are the agent of that one who was sworn in as clerk of court. So when anything goes wrong, you go after the one whose power they're using. Therefore, the fiduciary you're signing, no different than a CEO. If anything is done and it ties back into their customs and policy, that employee is not liable. The CEO is. The policymaker is. No different than a sheriff. One of his deputies interact with you. Those deputies, unless they've done something personally that involves them to remove sovereign immunity, only then can you make them personally liable. But ultimately, you're going after the bond of the county and that of the sheriff. Well, guess what, my friend? Same thing applies in this circumstance. They are merely the one you assigned through Form 56 is merely your agent. And if any liability comes up, they are coming to you, the one presumed to be the taxpayer. What have you done to show affirmatively that you're not the taxpayer, besides the fact that you're in fact showing that you're a taxpayer, but filed a Form 56 voluntarily, pretending to be them? There are many ways you can do things in names of trustees, effectively and privately, rather than this. Hype trains, gratification, lack of independent thought is what screws people over. He or she can only perform the duties authorized by the taxpayer. And even if they screw you over, you give them consent through Form 56 to do so. As indicated on Form 2848, power of attorney and declaration of representative. Don't they tell people to do this also? Don't they tell people to also file this also in those SPC groups, all those cracking the code, one man out, passing the buck stuff? Right. An authorized representative is not required nor permitted to do anything. An authorized representative is not required nor permitted to do anything other than the action explicitly authorized by the taxpayer. And if you tell them, hey, take the tax liability, they're not going to do that because it's still in your name. They can't take your tax liability. To then define what fiduciary is. A fiduciary, as used in this Form 56, is any person in a position of confidence. This confidence is just another word for trust. And the word trust, when it comes to anything dealing with pen and paper, is not just a layman term of, oh, I trust you. Go use my vehicle. You know, like a woman would trust a guy who basically serviced her engine real well down there. And then she trusts him all of a sudden by giving another engine to him. Like a hobo would trust that guy down the street who's always giving them $5, $10, $20, and some days $50. That's a lot of money to them. Every time they wave to him and smile, they trust, okay, maybe if I act nice, he's going to give me more. Right. Like your cat or your dog trusts you to feed him every time he gives you cues. Confidence, trust. But in this case on pen and paper, the trust is relating to structure, functional structure of estate planning, functional structure of knowing who to assign and who not to. They just use that substitute word under the assumption that you already know that there's a constructive trust going on, and this form is your consent to it. Because remember, this form triggers after something else has occurred, because IRS has just been notified that something else has occurred, which is that you have consent to that party being assigned as a fiduciary on your behalf. Therefore, to define who you've consented to that you're notifying them of, called a fiduciary. A fiduciary is any person in a position of confidence, a position of trust, acting on behalf of any other person, artificial or natural. They just leave it out there as persons. A fiduciary assumes the power, rights, duties, and privilege of the person or entity on whose behalf he or she is acting. Example of fiduciaries include administrators, acting judges, conservators, designees, aka beneficiary, executors. Executors exist as a form of trustee where there's no express trust, where there's just a lingering interest that someone as a third party just comes in and just swoops it up. We went over the difference between an executor and a trustee in this video. Guardians, aka, you're considered a minor, but you can't say you're not a minor anymore because you voluntarily did it yourself. You submitted yourself. They then do it themselves because as required by the IRS, they, the one assigned, is the one who's supposed to notify the IRS, not you, the one assigning them. So now you cannot claim incompetence. You cannot claim that you're your guardian. You cannot claim that you're incapacitated, duress, stress, unconscionability. None of that applies to you because you voluntarily, willingly, knowingly did so. Receivers, beneficiary, trustees of a trust, meaning if there's an express trust predominantly, but in this case, the trustee of a trust is the constructive trust called the courthouse so-and-so, which causes most people to fill out Form 56 because they've been told if you have a court case, fill out Form 56 and power of attorney and it gets dismissed. But it doesn't. It doesn't. It does not. Trustees in bankruptcy, personal representatives, persons in possession of property of a descendant estate. You're admitting that, let's not even go there. Or debtors in possession of an asset in a bankruptcy proceeding by order of the court. Let's not go there because I don't want to depress people any further. But nonetheless, that's what it is. A descendant estate is a taxable entity separate from the descendant that comes into existence at the time of the descendant's death. You, by filling out this form, are admitting that ens legis is a descendant estate and that you are, in fact, an ens legis who is civil and mortuus, creature of law. What law? The constructive trust, because the trust and the contract makes the law. And as you already know, civil and mortuus means you are civilly dead. Civil refers to contract. Oh, man. Most people are dooming themselves through the impulse of human social element and instant gratification of an outcome, which I always tell people to do their best to stay away from. I always try to deter people from that. But do you know how many thousands of people have bought the bandwagon of this Form 56? They're screwed over. And out of shame, they don't want to come out and say, this stuff does not work. Don't do it. So now all those social elements of community goes into the trash. Because now what does not work, you cannot come and tell people that it doesn't so that they don't fall into the same fate that you did. So what's the purpose of all that social element and bandwagon in the first place if no one can subsequently and perpetually benefit from it? Someone has to speak the truth. Most of you people have been duped. Your money's taken. No result. And in fact, the complete opposite. You're walking backwards. When and where to file notice of fiduciary relationship. Generally, you should file Form 56 when you create or terminate, which is the do better part. Sure, the problem has been introduced, which you probably did not know. But just because you don't know something does not mean it's not affecting you in a detrimental way in your life. See, most of these organizations like IRS has employees that they can loop over and over, fire and rehire. They will hire a fresh 21-year-old female or male. When you are old and you think all this is over, they'll start sending you letters. This stuff will come back and haunt many people if it already has not. But you can fix it now by terminating and using the same Form 56. The one who told you to get into that thing, did they tell you the possible way to get out if things go left? If they did not, that means one, they didn't care about you because their purpose was to lead you astray. And two, because they probably didn't know themselves. They probably just are a victim just like you are. They heard it from someone else and they just went with the social element, that mirror neuron in the human brain. They just mimicked it and they just sought after the animal impulse of instant gratification and they just distributed the information to you and you ran with it also. You didn't even question it. But when you did, you just got lazy with it. Can't really blame that on you personally because the education system have done that to many people. It teaches people to not use deductive and inductive reasoning. Just go along with the okie doke and maybe some television programming also. But the amusing part is most people who do stuff like this, there are supposedly the woke ones talking about not watching TV, talking about chemtrails, talking about, whatever it is going on. Yet they're falling for this fuckery by the same people who they say that they want to be free from. They send these counterintelligence agents in your circles. If I'm to begin to reveal some of the information that I have regarding most of these well-known names that people have lectures of as to how they are actually the detriment to most of these people to just lead you along, to lead you astray, most people will be upset at their entire life. Most people will be dumbfounded. But we're not here to do that. Instead of doing that, we'll just show you what the problem is on black and white. This is not a celebrity show. This is about substantive fact about you, what you need to do, and what you need to be aware of if you haven't done it. Generally, you should file Form 56 when you create or terminate A fiduciary relationship. File Form 56 with the Internal Revenue Service Center, where the person for whom you are acting is required to file tax return. In other words, the origin of the county of that is legas, whatever the closest IRS office is. That's where you basically fill out the same form to terminate it. Proceeding dealing with monies other than bankruptcy and assignments for the benefit of the creditor. This creditor here is not you, it's the one that you've assigned. A fiduciary who is appointed or authorized to act as a receivership proceeding. Go look up what receivership proceeding is. Or similar fiduciary, including fiduciary in aid of foreclosure. This foreclosure is not dealing with real property. You can foreclose contracts also. Or an assignee for the benefit of creditor must file Form 56 on or within 10 days of the date of appointment with advisory, group manager, advisory, insolvency, and quality office of the area office of IRS having jurisdiction over the person for whom you are acting. See publication 4235. Collective advisory group assets addresses for more information. In other words, when you want to terminate, these entities are the ones who you respectively sent it to. See, it's far easier to create the problem. Just file it with a court case and send it to the IRS. In some cases, they even tell you, right? But when I'm letting you know, when you want to terminate it, you not only terminate it in that same court case, and you not only send it to IRS, but you send it to these entities. And the address of those entities are in this publication. And what are the address of those advisory offices that you need to send it to? Because no one else will show it to you unless you go into this publication that Form 56 instruction has pointed you to. Here are the addresses. Getting liens released off properties. Why? Think about this. If the subject matter for these particular addresses are for the purpose of releasing liens, and you're using Form 56 to terminate that fiduciary relationship, does that not tell you what you've done when you assigned that fiduciary relationship through that Form 56? You put a lien on yourself. But so things doesn't get too depressing, here are the addresses you send it to based on which one you're closest to. Based on which one is closest to the county of origin of that is legas. It's right there. Here are the office numbers based on the states. And here are the addresses, phone number, and faxes of said locations based on those states. There are fixed numbers of those. Whichever one is closest to you, there it is. The least you cannot say is someone is not telling you and someone is not showing you. Lastly, 26 USC 6903, one of the administrative codes that governs that Form 56. Notice a fiduciary relationship. A, right and obligation of fiduciary. They begin by saying right before obligation, because it's no different than rights and obligation of contract, to which you've expressly consented to. Upon notice to the secretary that any person is acting for another person in a fiduciary capacity, such fiduciary shall assume the power, rights, duties, and privilege of such other person in respect of any tax imposed by this title. Meaning you are supposed to file the returns as though you're the taxpayer. And you, the fiduciary, are supposed to speak on their behalf as to why they can do so or why they cannot. But you don't retain personal liability of tax because you reserve the right to not do so. You reserve the right to not volunteer. That Form 56 does not make them a volunteer to incur your tax liability, the one who is assigning them. That's the part people don't get. Except as otherwise specifically provided, and except that the tax shall be collected from listen to this. Except as otherwise specifically provided, and except that the tax shall be collected from the estate of such other person. They're telling you the fiduciary is not liable. And the extent of it is just as an agent. And do you think someone you assign as a fiduciary will not evoke this particular exception? Do you think they're stupid enough not to do so? This is their way out to what you think you're doing. Until notice is given that the fiduciary capacity is terminated. So now you see, not filling out the Form 46 to assign is actually the way to make them liable for tax. They're not going to show you what you do to trigger that. Of course they're not, but they're going to tell you, look, you can terminate that notice if you think it's not benefiting you because of this exception. Manner of notice. Notice under this section shall be given in accordance with regulation prescribed by the Secretary. That notice prescribed according to the Secretary is what we've been going over before this point. That's why we saved this for the last, because this eventually refers you back to Form 56 in that publication. The notice and the accordance to the regulations is in that publication that we've just shown right here. And when it's the statute in public law, it's in 68A Statute 843, Public Law 94-455, Title 19, subsection 1906B, and year 1976, 90 Stats 1834. Beautiful people, the least you cannot say is that someone is not telling you and showing you these things. Until next time, take care. Best of luck.